The rules governing responsibility for a Maryland car accident are pretty straightforward. Certainly, the driver or operator of an automobile that commits an act of negligence is responsible for his or her own conduct. Likewise, the owner of the vehicle is presumptively responsible under Maryland law for the conduct of the driver. Now, this is perhaps the most easily dispelled presumption under Maryland law and typically requires no more than the owner stating that the individual that was operating the car at the time of the accident had their permission to drive the car, but they were not in it and had no way to control the conduct of the driver. Now, a third theory that might be available in very particular circumstances is one involving negligent entrustment. Here the law says that if an owner has reason to believe or knowledge of dangerous tendencies or proclivities of the driver, then that individual probably should not let the other dangerous individual drive his or her car, and if they do, they might have committed an independent act of negligence in doing so. Now, the rules are different when it comes to rented cars. Typically, and certainly one that has ever rented a car from Hertz, Avis, Dollar, Budget, or any of the major players knows that you're typically given an option when renting a car. You can purchase the insurance that is offered by the company, or if you have a different vehicle and private car insurance, you can opt to have your private car insurance cover any potential loss. It's always a good idea to confirm with your insurance company or agent that in fact such coverage exists. The big difference here, though, is that the driver of a leased vehicle is always going to be responsible for the conduct, for their conduct. There's not the option of pursuing the owner of the vehicle. There's a piece of federal legislation that says that the owner of a leased vehicle, despite state law, case law, or statutory to the contrary, is simply not responsible for the conduct of the driver.